Phil Silberman with the Silberman Law Firm here today, and we're going to go over a quitclaim deed. In the state of Texas, we don't use quitclaim deeds to transfer title to property very often. Most states in the union use quitclaim deeds fairly regularly. A lot of times, someone will call up our law firm and say, "Hey, my lender told me I need a quitclaim deed." That's usually a national lender like Wells or Chase or somebody big like that, and they're used to telling clients that they need quitclaim deeds. In the state of Texas, we don't use them very often. In cases that we do use them, it's usually because the seller or the grantor is unsure of what the grantor owns in the real estate, if anything. So out of an abundance of caution, so that the seller doesn't end up getting sued by making any warranties, by promising to sell or defend a good title to a property, the grantor is just going to say, "Hey, look, I'm transferring this property to you, Mr. Grantee. I don't know if I own it. If I do own it, whatever I own goes over to you." That's the purpose and what we use quitclaim deeds in Texas for. If you try to use it on a regular deal and you end up trying to get title insurance, or the buyer later gets title insurance, the title company's not going to insure that title. So you only use quitclaim deeds in very limited and rare circumstances in Texas. That being said, let's go ahead and get started with this deed. The first thing you see in almost all of our deeds is the notice of confidentiality rights. That goes up top on your deed in the state of Texas. Then you have the title of the deed, in this case, quitclaim. If it were a special warranty deed or a general warranty deed, it would say that. Note that the title of an instrument is not dispositive of what that instrument really does. So this could say quitclaim deed, but it might do something completely opposite. Or a deed could purport to be a special warranty deed, but it does something like a quitclaim. So don't just get bogged down in the title and think that's automatically what the instrument does. You actually have to read the instrument. Date of the deed, that's not really super significant. That's just the date that goes on there. The real operative date is going to be the date that the grantor signs it. So our grantor or seller is Sue Seller, a single person. There's the grantor's mailing address. Our grantee is Bill Buyer, a single person. Our grantee's mailing address goes there. The consideration clause is very standard: cash and other good and valuable consideration. Sometimes in the state of Texas, you see for $10 in good and other valuable consideration. That doesn't mean that the buyer actually paid $10 for the property. That's just a recitation that comes out of tradition. Then you have the property with a legal description. You always want to use a good legal description, not the truncated version on an appraisal district website. And then you have the operative grant language, and it says, "For consideration, grantor quitclaims to grantee all of grantor's right, title, and interest in and to the property." That's all of it. That's all it says. And it goes on to say that the grantor heirs aren't going to have any claims, but the grantor quitclaims. Couple notes here. One, there's no warranty clause. In a special warranty deed or a general warranty deed, you'll see a warranty clause. And let me minimize this and show you a typical warranty clause that's sampled out of our blog. And it says, "Grantor binds a grantor and grantor's heirs and successors to warrant and forever defend all and singular the property to grantee and grantee's heirs, successors and assigns against every person whomsoever lawfully claiming or to claim the same, any part thereof, except as the reservations," yada, yada, yada. That's a general warranty clause. That's a good warranty where the grantor is warranting to defend the title of that property against anybody claiming title against grantee. And you'll notice in our quitclaim deed example, none of that is there. And that's why in the state of Texas, title companies won't insure this kind of deed. So if you get a quitclaim deed from somebody and years later the grantee goes to sell the property to somebody else, the title company is going to run a title report, and they're going to pull title evidence, and they're going to see there's a quitclaim deed in the chain of title. And they're going to make the seller in that transaction, or the grantee in this, whoever got the quit claim deed or whoever currently owns the property that has the quit claim deed in the chain of title, they're going to make them go back and fix it and replace it with a warranty deed. And that may not be easy if the grantor on this quit claim deed has been dead for many years or is not to be found. So this is why quit claim deeds really get people in a lot of trouble in Texas. Then we move on through our deed. And the final thing here that most lawyers will put is the instrument was prepared based on the information furnished by the parties. No independent title search has been made. That's because as lawyers, we often prepare these deeds with the information that's given to us. We're not doing full title searches, so we don't want any liability associated with it. And then sue seller as the grantor signs in Texas. It's always the grantor that signs. Usually the grantee does not sign the deed unless the grantee is making specific promises. And then you've got a notary block with showing you where the deed was prepared. In this case, it defaults to our law office. And then after recording the deed, the deed's usually returned to the first grantee to satisfy the delivery requirements of deeds in Texas. And then you've got a declaration of authenticity that deals with electronic recording in Texas. So that's all about quitclaim deeds in the state of Texas. And hopefully that's been educational and helpful. As always, remember to like and subscribe. I appreciate you watching.